The other approach would be what I refer to as the no exemptions approach, which says if the law is generally neutral, right, genuinely neutral, that is, there are certainly plenty of laws that purport to be neutral, right, but in fact it's really cover for a pernicious, intolerant purpose. In the book, I actually argue that the French law about ostentatious religious symbols in the school was a case of a purportedly neutral law that was really, in fact, a case of intolerance against Muslims in particular. But if the law is genuinely neutral and it promotes the general welfare, then there should be no exemptions given to it, right, if those exemptions would shift burdens onto other people. And I want to emphasize that because sometimes exemptions from the law are not burden shifting, and it seems to me in those cases, exemptions probably should be given for legitimate conscientious objections. So a very simple example that'll be familiar to everyone who's ever had a driver's license, right? The rules governing driver's licenses always require your photograph to be taken without any headgear, right? But why not give an exemption to the Sikh man who must wear his turban or the Orthodox Jew who must wear his skull cap to that law? It doesn't shift burdens on anyone, it doesn't defeat the purpose of law, and it allows the individuals to discharge their religious obligations. That's an example of a non-burden shifting exemption. But with respect to exemptions that would shift burdens, it seems to me that it's fundamentally unfair, right, to the rest of society to grant exemptions to those laws for conscientious objections. And let me just conclude by mentioning that this view I'm describing, the no exemptions approach, is roughly the view that the United States Supreme Court adopted in 1990 in an opinion by Justice Antonin Scalia. This was a case called Employment Division versus Smith. Mr. Smith was a member of a Native American religion that required its adherents to use peyote, which was an illegal narcotic. Okay? Now, the thing about peyote, which makes it very different from marijuana, not that I know this from firsthand experience, is that peyote is apparently quite disgusting. You know, it is an illegal narcotic, but there's nothing pleasant about using it. Right? It tastes awful. So you really only do it if you feel you have a religious obligation in order to use it. Well, he felt he did. He used it. He got in trouble for using peyote as part of his congregation, and he lost his job. He was fired. Okay? He then filed for unemployment benefits and was denied them on the grounds that you were not eligible for unemployment benefits if you lost your job because of use of an illegal narcotic. And that's what he challenged in a case that went up to the United States Supreme Court. And what Justice Scalia essentially said is very close to what I described as the no exemptions approach. He said a general law of neutral applicability, right, such as laws prohibiting the use of certain illegal narcotics, the state doesn't have to create exemptions from those laws just because people have religious objections to them. So Mr. Smith was out of luck. Now, as I said, this was the position the United States Supreme Court adopted. It is not today the law of the land. As my research assistant, who scrutinized lots of cases in connection with the work on this book, said, Congress and the states adopted a scorched earth policy towards Employment Division versus Smith. There was a terrible reaction to it. Prior to Smith, right, it was much easier for someone with a religious objection to a law to get an exemption. Many states, probably all of them at this point, interpreted their state constitutions as providing exemptions from laws of general applicability if they burdened people who had religious objections to them. The federal government, this went through several iterations, but in the end the federal government adopted a rule that basically constrained the federal government not to enforce federal laws that would unnecessarily burden the free exercise of religion. Right? So even though the official interpretation of the First Amendment of the United States Constitution, according to the U.S. Supreme Court, is what I'm calling the no exemptions approach, in practice it has almost no bite at this point. But of course, whether that will change in the future is something that remains to be seen.